Welcome to the second symposium of the State of Our Constitution series. It is called the North Carolina Constitution and Property Rights, and as Troy mentioned, it's part of a three-part series which explores the history, enforcement, interpretation, and importance of the North Carolina State Constitution. As Troy mentioned, I urge you to pick up one of these. It's amazing how something like this can live and breathe in ways that we don't think about until we need to explore the breadth and the life of it. But it's there, and it's theirs for you to take. This symposium is being made into a documentary that can be viewed on Carolina Journal TV. It's only appropriate that we discuss the state constitution and property rights in this beautiful historic Capitol building. Here in this very room, for instance, debates with House members regarding property rights, constitutional interpretations were put forth. It's amazing to me that the legislature meets where it does now and not in this beautiful sanctuary that was just that for so long for state lawmakers. It's also housed debates, and hopefully tonight our discussion will make people think in ways about certain issues that maybe they have not thought about before. My name is David Crabtree. I am honored to be a part of this evening and to serve as moderator for this distinguished panel. One more note about this building. Many of you may know the history of this building, but for those of you who don't, and those of you who do, and you don't mind a bit of a refresher course, after a fire in 1831 burned down the original Capitol, the General Assembly ordered that a new one be constructed. This architectural gem was completed in 1840. It was designed by architect Alexander Jackson Davis. This Capitol is one of the best examples of Greek Revival architecture. Among the many artifacts in this building is housed numerous busts of notable North Carolina figures and a copy of Antonio Canova's original statue of George Washington, which reveals how knowledgeable many early Americans were with classical Roman history. In ancient Rome, constitutions had great importance. It was not a question that they were unimportant or if they would change, but how they would change. In that spirit, we gather here tonight. Before I introduce the panel, let me thank our sponsors. They are listed in your program: Gene Boyce, Mr. and Mrs. Charles Carter, the Honorable Rusty Duke, the Fair Annexation Coalition, Duplin Winery, Ruthie Harrell, Mark McNeely, Michael Munger, George Stevens, Stop NC Annexation, the Honorable John M. Tyson, North Carolina Property Rights Coalition, and the Williams Mullen Foundation. We thank you for making this discussion and this ultimate documentary possible. So now let me take an opportunity to introduce our panel. We'll go from my left and proceed down. First is John Dinan, Wake Forest University political science professor, author of The American State Constitutional Tradition. Seated next to him is the Honorable John M. Tyson, former North Carolina Court of Appeals judge, current recall judge for the North Carolina Court of Appeals. Kieran Shanahan, principal in the Shanahan Law Group and founder of NC Property Rights Coalition. And Emmett Boney Haywood, Raleigh-based attorney whose legal practice is devoted to property rights issues. Our thanks to all of you for being here, taking your time to be here. A leading antebellum American statesman, Daniel Webster, once said, "No other rights are safe where property is not safe." With that in mind, let's start by defining some terms and focusing our attention on how the North Carolina State Constitution does or does not provide constitutional protections for private property. Professor, we'll start with you, and here's where we'll go with this. Section 19 of the North Carolina Constitution states, "No person shall be taken, imprisoned, disseized of his freehold, liberties, or privileges, or outlawed or exiled, or in any manner deprived of his life, liberty, or property, but by the law of the land." How does this section compare with the protections that other states give their citizens?
Well, North Carolina's constitutional provision regarding property is highly unusual. In fact, it's unique among the 50 states in declining to be any more specific than that about the protections for property. If you look at the other 49 state constitutional provisions, a number of them are very explicit. Property may only be taken for public use. The determination of that question of whether it's public use shall be a judicial question rather than a legislative question. Just compensation must be provided. Many of the other 49 state constitutions are very explicit about adding those in their provisions. Now, the North Carolina Supreme Court has read the law of the land clause as providing a number of those same protections. And the North Carolina legislature, by statute, has provided some protections. But the fact remains that North Carolina's property provision is unique in declining to be as explicit as many of the other constitutions in the U.S.
So, Your Honor, in what ways can this state take a citizen's, business's property? I mean, does eminent domain fall into this?
There are basically three ways that the state or a governmental subdivision of the state can take property. One is by an outright physical occupation of the property. And every time that a governmental entity or person with the power of condemnation has a physical occupation of property as a per se taking. The second way that property can be taken is through a damage to the residual. And that is when only a portion or a partial taking occurs. The property owner then can bring an action to claim that the remainder of his property has been suffered damage over and above the amount that was physically taken. And then the third way that the government can take property is through what's referred to as a regulatory taking. And that's without a physical occupation, but that's when governmental regulation has deprived the owner of all reasonable economic use of the property. And in each one of those three cases, just compensation or damages would be due to the property owner.
Kieran, Shanahan, we often hear discussed about public purpose and public use where land is concerned. Help us understand the difference.
Well, you can't get far into a discussion about property rights without encountering the most famous case in, I think, recent memory, the Kelo versus New London case. And in that case, the court expanded, I think, the definition of public use. And the Fifth Amendment to the United States Constitution says that there'll be no taking of private property but for public use and upon payment of just compensation. And in the Kelo case, the court expanded that definition to include public purpose. I think we might all agree that public use might include a road, for example, or a police station. But in the Kelo case, we had private property being taken from individuals to be given to other private entities for economic development purposes. And the Supreme Court said that was okay. In North Carolina, the case law is developed in a way that has really used public purpose and public use in an interchangeable fashion. And that really is the number one assault right now on our private property rights as enunciated in the Constitution.
I hope the director won't mind if I step out. I hate to ask anyone a question if I can't see their face. So I know your focus, or the focus of your practice, obviously involves a lot of what we're talking about tonight. So what local laws protect or take away an individual's property rights?
Well, local governments frequently limit what you can do with your property. They do that by way of zoning and land use regulations. They do it by landscape ordinances. They do it sometimes just by drawing a line on a map and showing this is where we want a road to be. That can have a devastating effect on someone's property. And the question becomes, has that regulation gone too far? As Judge Tyson said, a regulatory taking can be a taking, but it has to destroy all economically viable use of the property. Anything short of that is more questionable, and the courts have applied a balancing test, looking at the use that the government, whether it's a sound, good use that the government wants to put to the property, counterbalancing that with the diminution, the reduction in value of the property that this regulation is going to cause to the property, because no doubt zoning and other regulations can reduce someone's property's value.
We touched on this just a moment ago, but the state of North Carolina has the right to take one's property through eminent domain. It would be beneficial then for us to discuss in what circumstances and for what purposes the North Carolina government can invoke eminent domain power, and what possible problems currently exist, and what constitutional protections for property owners do or do not exist. Judge Tyson, will begin with you with this question. What constitutional protections protect private property owners against abuses and improper uses of this power, and how have the North Carolina courts interpreted these provisions in key cases?
North Carolina does not have an express prohibition from for governmental taking of property. However, in the case of Finch versus the city of Durham, our Supreme Court stated that Article 1, Section 19 of the North Carolina Constitution is the functional equivalent of the U.S. Constitution's Fifth Amendment, that private property shall not be taken for public use without just compensation. So the protections up until the Kelo case was a governmental taking had to be for a public use. And then the property owner had a right to just compensation. Now, in North Carolina, the amount of damage that a private property owner has suffered through a taking can be determined by a jury. So if the property owner demands the amount of damage that the property owner has suffered through the taking is determined by a jury of their peers. Beyond that, those constitutional provisions, there are certain statutory provisions that protect private property owners depending upon who is taking the property. For example, if a utility such as a gas company is taking property, there is a minimum amount of width and a maximum amount of width in the statute that is allowed, anywhere from 80 to 100 feet. If a railroad is taking your property, there's also a maximum width that the railroad can take from the property. Again, it's 100 feet. So in addition to the constitutional protections of public use and just compensation and the right to a jury trial, depending upon who's taking the property, there may be more specific statutory restrictions on the entity's ability to take.
Kieran, Shanahan, in the past few months, the state of North Carolina has tried to block a new federal license needed by Alcoa to generate and sell electricity from dams along the Yadkin River for another 50 years. Is this unprecedented, and is there a constitutional protection for business interests?
The answer is yes, it's unprecedented, and unfortunately there's very little protection for a business owner. Oftentimes we think of property rights as someone taking your home or putting a road in front of your home or a sewer line, but oftentimes it involves government takings of entire businesses. And it's unprecedented, the movement afoot to take Alcoa's property over in Stanley County. They've run a plant there for a number of years. It's a regulatory facility that generates power. And the government in North Carolina, at least some individuals, believe that the government taking it over for government use from private citizens is a good use of taxpayer money. Now they're going to have to take land owned by a private corporation, who's the single largest taxpayer in the county by way of example, take it off the public dole, pay for that property just compensation, and then it becomes property that the government doesn't recognize income off of. And so it's really not a good use of government resources to do it, and it's a good example going on today of where government is encroaching into privately held property.
Professor, let's talk about individuals' constitutional protections. Are there state constitutional protections, and does federal law offer protections to individual property owners in North Carolina when the state wishes to seize property?
Let me focus on a particular contentious issue involving takings, and that has been referred to several times here, when the government takes your property, not because they need to widen a road, not because a courthouse needs to be built, but because they view that property as potentially more economically profitable if there was a shopping mall there or something of that sort. Now, the U.S. Supreme Court, as has been noted, said in the Kelo decision in 2005, the federal Constitution will not be read to bar the taking of private property for economic development purposes. So any protection that's going to come to individuals is going to come through state constitutions or through state statutes. Now, in the several years since 2005, the Kelo decision, 8 states have taken a look at their state constitutions and have said, let's amend the state constitution and let's provide tighter protection. So, among these 8 states that have amended their state constitutional provisions, several have said explicitly, economic development shall not constitute public use. Or they have said, the determination of what constitutes public use shall be a judicial question rather than a legislative question. That is, we will not defer to a municipality or legislature if they say we're taking it for public use. We will investigate that. North Carolina has not so far tightened its constitutional provisions as these other states have done post-Kelo. A constitutional amendment has been proposed in the legislature. It has received some support in the House. It has not so far received such support in the Senate. There have been some statutory tweakings, but right now, so far, North Carolina has not tightened its constitution as these other states have done.
Step back out again. In what ways can local governments, I like this word, in what ways can local governments cooperate with certain private interests when seizing an individual's property? And are there state constitutional provisions against this?
Well, I've been recently observing an interesting phenomenon that I had not seen until recently, and it arises out of this. Often, in order to get a project approved, a developer will have to, the municipality will require the developer to donate land, to build roads, to widen a road in front of their development, maybe to donate land for a greenway easement. And those are called exactions. And the courts have upheld those as long as they're roughly proportionate to the burden that the development will put on the roads and other services. But what I'm seeing now is sometimes municipalities are requiring what are off-site improvements. In other words, they are asking the developers to build a road. Or sometimes the developer needs a sewer line, and they say, well, we can't get our sewer line from A to B because we don't own the land that the sewer line will cross, or we don't own all the land that the road will cross. And the municipalities are saying, that's okay. We'll use our power of condemnation. We will condemn your neighbor's property to enable this road to be put in. Now, you'll have to pay for it or pay for most of it, but it's an interesting phenomenon. North Carolina's not ruled on this, and I haven't had any clients who've wanted to fight it or they've wanted to, but it can be very expensive, and we'll talk about that later. But anyway, it's just something that I've been observing, and I've probably seen it in about 10 instances recently.
Focusing specifically on the question regarding compensation for property owners whose land has been seized via eminent domain, how is compensation for such takings determined in this state, and are there problems and possible reforms with how compensation is determined? Here's the question to extend that just a little bit. A major concern in this state is the issue of just compensation when property is taken for a public project. So, does North Carolina offer just compensation for property owners, and do municipalities offer just compensation?
Well, this is my soapbox item, so if y'all will bear with me. North Carolina has 2 statutory schemes in how people whose property is taken outright, physical taking, for a road or some sewer line or airport expansion or some public use. The first statute is what I'll call the state statute. That's in Chapter 136, and the compensation in that statute says that where part of your property is taken, the government has to pay you the difference between what your property was worth before it was taken by the government and what it's worth afterwards. With consideration being given to any benefits that the project might cause to your remaining property. Again, it's the fair market value. If all of your property is taken under the state scheme, you are entitled to the fair market value of the property immediately before the lawsuit's filed. That's the date of value. Municipalities have a different scheme. They are required to pay the greater of the land that's taken, or what the property was worth before, what it's worth after, and the difference. What could happen is that for example, a DOT taking, they could say, well, we're taking 10 acres of your property, but because what you have left is going to be worth more than what it was before, we don't have to pay you anything. The benefits outweigh the damages. Now, some municipalities have gone and gotten permission from the legislature to choose which statute they go under. And I think that's really fraught with abuse. I have not observed any abuse yet, but it is there. Because in one case, for example, a sewer line or something, the municipality could say, well, we don't have to pay you anything for this easement we're taking because your property will be worth more afterwards. Now, the other issue that I really want to talk about is, this is one of the greatest powers our government has, to take your property when you don't want to sell it. The government in this country can't tell you what to think or what to say, and when it takes your property, it can't set the price. That's up to a jury in this state to do it. And a lot of people don't choose to fight because it's expensive. Remember, you're only entitled to the fair market value of your property. You have to pay for your own lawyer. You have to pay for your own real estate appraiser. You have to pay for your own engineer, your land planner, all the experts that you have to hire to fight the government. And how can you be made whole if you have to pay all those things out of the compensation you get? In addition, and I'll just touch on this, if there's no federal money involved, then the local municipalities are not required to pay your moving expenses and your relocation expenses. Although under the state, if the state does that, they are required to do that. They're also not required to pay the loss of goodwill for your business or just for the land in the building, not for any lost profits or anything. So it's very difficult when a business, and usually it's a small business, is taken for a road project or some other use.
Professor, do other states provide in their constitution for more explicit guidance on this compensation?
It won't be surprising to learn that many other states are more explicit in their determination of how just compensation is determined and what provisions there are for individuals who want to challenge such a determination. Let me give two types of provisions that you'll find in some, by no means all, but some other state constitutional provisions. For instance, some state constitutional provisions are very explicit that an individual who wants to challenge a determination of what is just compensation is entitled by Constitution to a jury determination, rather than leaving that to the statute or the legislature to allow that to you if they want. Second thing that you'll find in some state constitutions, just a few in this case, some state constitutions are very explicit that by constitutional requirement that if you prevail as a property owner in challenging a just compensation and you show that actually they were offering you much less than what is just, you must be reimbursed for your attorney and appraisal fees. So there are several models to choose from if one looks at the other 49 state constitutional provisions.
For Kieran Shanahan, when an individual's land is seized via eminent domain, what are the implicit and unintended costs to the private property owner and to the greater community?
Well, there's certainly a myriad of them. Well, the way it works in North Carolina, once a municipality decides to take your property, and ordinarily they will try and negotiate with you, but assuming that fails, they literally go to the courthouse and deposit what they determine to be the fair market value of the property, and they send you a notice that says you have 30 days to be off the property. In North Carolina, there are sometimes municipalities do it. We have an entity here in the Triangle called the TTA, the Triangle Transit Authority. Not many of those folks are actually elected by anybody, but they actually were given by statute the power of eminent domain. They were going to build a rail line, and I think it's one of the few projects that even Washington decided was probably not a good use of taxpayer money. And so that project is sort of derailed for now, but they have seized and taken people's businesses, and they're holding that land. There's no opportunity for the landowner to get the property back. A lot of times when local municipalities are doing their urban renewal, their economic development, it oftentimes is in blighted areas, and it disproportionately has an impact on low-income folks. So if you're in an area, maybe you've got a service station or a small convenience store, the ability to replicate that somewhere else is very difficult. You're not compensated for the value of your business under North Carolina law. In fact, you're instructed by the judge that you cannot consider that under North Carolina law. Where are individuals going to go to put their businesses, to put themselves back in a position that they were before? Again, I think I pointed out earlier that you have to also take in mind that oftentimes we're taking land that's on the tax rolls and taking it off the tax rolls if the government is taking it for its own use. And those things need to be taken into consideration. So the deck is very much stacked against an individual landowner in an individual case, and the costs are quite high. People who have been oftentimes victimized or become the victim of eminent domain, they never forget it because land is such a unique thing, and you feel so violated and so helpless in the process. North Carolina is very much behind the curve in how it deals with eminent domain issues.
Judge Tyson, you've been listening to this. Should juries be used when the government seizes property for, quote, economic development?
It's very rare. In fact, I have not found a North Carolina case where a jury has been asked to determine whether or not the purpose for which the property is taken is valid, whether it is truly a public use or a public benefit. That was the issue in the Kilo case, where the property owner there was actually challenging the purposes for which their property was taken. The jury, as I mentioned earlier, does determine the amount of damage that a property owner has incurred, and we've heard that it's the difference normally between the value of the property before the taking and the value of the property after the taking. That's the question for the jury of what is just compensation for those damages. There are some statutory exemptions for takings by cities and towns and utilities and railroads, and it's a statute that goes back to 1852 in North Carolina. It's under 40A 3A, and this issue came up in the case of Progress Energy versus Stevenson. This was a fifth-generation farmer down in Columbus County where Progress Energy wanted to extend a high-tensile transmission line across his property. And the statute provides that no condemnor or no taker of property shall be allowed to condemn for its use without the consent of the owner's burial ground, usual dwelling, house, yard, kitchen, and garden, unless the condemnation of such property was expressly authorized by statute. So Stevenson challenged Progress Energy's right to take part of his garden and his usual dwelling house. Now, in that opinion, I disagreed with two of my colleagues and wrote the dissent, which would have found for that property owner, because the only evidence before the judge at that time was the property owner's testimony of where his garden and his house and his burial grounds were located. The utility had not offered any evidence to rebut the property owner's testimony. But that's the one rare case where a property owner is actually trying to challenge the uses for which the property taken. Juries normally only determine the amount of damages that the property owner has incurred.
Let's turn our attention to another way private property can be affected by government. We're talking about annexation, local laws, and to provide some examples of how involuntary annexation and local laws have affected private property owners. And Kieran, Shanahan, let's start with you. Here's the question. Involuntary annexation and local laws can threaten individuals' property rights. In what ways are these laws a threat, and what does the state constitution say or not say about this?
Well, unfortunately, the state constitution says nothing directly about it, but implicitly, I think there are the same fundamental notions of takings do apply. Under North Carolina law and statutes, there must be some sort of meaningful services delivered for there to be annexation. By annexation, we're saying as a municipality reaches out around it to take in neighborhoods, sometimes large neighborhoods. And the first problem with it is that those people who are being annexed don't have a vote on whether or not they're going to be annexed. That makes us unusual for the rest of the country. Secondly, oftentimes there are very little or minimal services or value that's being added to the people who are being annexed. And so it inherently is a problematic situation. And so North Carolina requires, there are statutes in place about services being provided within a period of time, but it's really one of if you think about it, I like to say the federal government can print money. The state of North Carolina has trust funds that they borrow from time to time. But local municipalities, much like you and I, they have to balance their checkbooks, and they have to have income and revenue. And so they're always looking for new sources of revenue, and annexation happens to be one of the favorite ways of doing it. The unfortunate part oftentimes for people who are being annexed, they don't want the services, they don't need the services, and there's nothing of value being provided to them. And oftentimes, infrastructure that they've been put in place, roads, septic, gated communities, oftentimes in effect is a taking of their property. In those cases are now working themselves through the system. But it is a definite problem occurring all over the state, and it has a very detrimental impact. Again, it's that situation where a neighborhood is affected, or a few people, or sometimes a large neighborhood, and the neighbors are usually unaware of what's going on. They've got to organize. They have limited resources with which to fight a system that's kind of stacked against them, if you will. And the showing that the municipalities have to make is generally very low to cross the annexation threshold.
Judge Tyson, so how can the government condemn private property for the use of other private entities? What other ways can a local government take away private property, abuse zoning laws, local laws? We've heard a lot about what's happened in Fayetteville in the past couple of years.
Under a strict reading of the Fifth Amendment, which our Supreme Court has said is the functional equivalent of our state constitution, Article 1, Section 19, no one with condemnation power should be able to take private property and give it to another private individual. The professor said earlier that we have not adopted a amendment that would, what's referred to as an anti-kilo amendment in this state, even though many other states have. The problem comes in where you have a city or county or some other group acting as a proxy for a private individual. And Emmett described earlier where a developer comes in and wants to build a project, and the city or county requires them to improve a road, extend sewer or water, and the only way they can do that is through another property owner's private property, and the city ends up condemning that property for that utility easement or that road easement. I don't think anyone here would question that's benefiting a private individual, even though it's a public entity that's taken the property. The second question that you ask is, in other ways can a local government? We've mentioned regulatory takings. Again, they're not coming onto your property, but they are putting restrictions on how you can use your property. And if the restrictions are to the point that you're deprived of all economic benefit or uses of that property, then you as the property owner are entitled to just compensation. However, that's been a very strict case. We have seen a situation where we've had billboard amortization ordinances where billboard companies can use their properly permitted, legal when built property for 7 more years and it goes away. In my hometown of Fayetteville right now, we've got an ordinance that was just passed in January by our city council for auto salvage yards, where they're giving auto salvage yards, who in some cases have been there for 50 years and who render valuable services, they're giving them 3 years to amortize their business, and then they must shut down without compensation. Now, the problem with these ordinances is that you only have 60 days to challenge those ordinances. 60 days from the day the ordinance is passed. Not when it affects you, but when the city council puts the ordinance into effect. So those are examples of how they can take your property away through regulation and through amortization statutes.
So either constitutionally or statutory, are there grounds to challenge this?
Well, sadly, all the constitutional challenges to forced or involuntary annexation have failed. People have argued that it was a denial of the right to vote because the people being annexed are not, they're not citizens of the municipality, so they can't vote on it. That it's taxation without representation, that it's an unlawful delegation by the legislature, because the legislature has given the power to the municipalities to expand their boundaries. It's a violation of the right to a jury trial because they've made all these arguments and they've all failed in the courts. Property owners have been more successful in challenging on statutory grounds. And I'm going to let Judge Tyson talk about the Nolan versus Village of Marvin up in Union County, it was a case he was involved in which the property owner did prevail in that case.
That was a rare case. It was a case where the town of Village of Marvin, which was an incorporated town, sought to involuntary annex a subdivision and provide absolutely no services to the subdivision above what it was already getting from other sources. And two of my colleagues on the court said that was okay, that a city is not required to provide any services whatsoever, even though the statute clearly says that high-quality urban services must be provided if you annex. I wrote a dissent. It was taken over to the state Supreme Court. I think that Gene Boyce was involved in the appeal, and fortunately, the state Supreme Court, the majority of the Supreme Court, agreed with me and said that if a city is going to annex, it has to provide meaningful municipal services. The only services that the Village of Marvin was providing was a municipal tax bill. That was the only thing that those folks were getting that they weren't already getting from somewhere else.
Professor, how does North Carolina statutory laws compare with other states? And what other state statutes or constitutional amendments can provide examples for North Carolina to strengthen protection against what could be termed annexation abuse?
North Carolina is unusual among the states in permitting involuntary annexation so readily without an opportunity for participation by those being annexed. Of the states that provide for annexation, not all states do provide for annexation, of those that do, a clear majority permit the targets of annexation to vote in a referendum, if they so desire, on whether or not they see a benefit in being annexed. Now, in fact, Colorado has gone so far not just to make this a statutory requirement, but Colorado has changed its state constitution to guarantee people by the Constitution a right to a referendum if you're the targets of involuntary annexation. Now, a proposal to make a statutory requirement in North Carolina that would allow targets of annexation to be allowed to vote in a referendum has been proposed. In fact, it's received support from a legislative study committee reporting earlier this year, along with several other proposals to increase protection for the targets of annexation, perhaps to provide oversight by another body, perhaps to provide tighter provision for the requirement of services being provided. Those matters are currently under discussion, under debate in the North Carolina legislature on statutory grounds. In short, though, for those seeking to reform North Carolina's annexation rules, there are many models to choose from and guidance to be sought from the way other states do this.
We've had a lot of discussion about issues that are troubling, problematic, in need of reform. So let's talk about solution. If we're looking for solutions for reforms to change and turn these problems into non-problems, or at least less problematic than they are now? Where do we begin? And Kieran, Shanahan, let's begin with you on this. I'd like to hear from everybody on the panel on this.
I think we should begin with the North Carolina Constitution. As our professor said, that Kelo left the door open for each state to control its own destiny with regard to property rights. It's the one area we, the people, still have some power. The problem, if you will, in North Carolina is to have a constitutional amendment, it must go through both houses of the legislature. Last year, the House, by overwhelming majority, bipartisan support, passed an amendment to the Constitution of North Carolina, an anti-Kelo amendment. It wasn't the best language, it wouldn't have been my language, but it was a good step in the right direction. It promptly went over to the Senate, where it was assigned to a committee that had not met since 2001. The problem when you have people who are given power, they hate to give it back. And therein lies our biggest challenge, I think. David, I would say the number one thing we need to do is to amend the Constitution of the state of North Carolina to limit government taking to a public use. And by that, I mean to exclude specifically takings for economic development purposes. And the second aspect of that would be to have a just compensation provision that has meaningful teeth, that actually incentivizes the government to pay just compensation and gives counsel, advice, and meaningful opportunity to the court system for those people who, when a public purpose has been shown, have a right to be justly compensated.
Amending a constitution can be dicey, needed, but it can be problematic in and of itself. Is that a solution?
Well, many people think it is. I mean, it's certainly a start. You know, we're the only state, as I think Judge or the professor said, that doesn't have language that at least parrots the Fifth Amendment, nor shall private property be taken for public use without payment of just compensation. We don't have that in our Constitution. We don't have that. I mean, the courts have interpreted it and applied it and said, well, yeah, it's basically there, but it's not. And it could be taken away. You know, they're just, I guess one of my biggest concerns is also I want my clients and people whose property is taken to be made whole. I want the government, if they're going to take someone's property, they need to reimburse them for their attorney's fees, their appraiser, their engineer. They need to do simple things, just as simple as giving the property owners a copy of the appraisal upon which the government's offer is based. Some do. The DOT now gives those appraisal reports, but many municipalities do not. I think people who are going to be annexed need to be able to vote. Businesses need to be fairly compensated. And relocation and moving expenses need to be paid to everybody who has to move for a public project, not just, you know, people who have to move for a state project, but for a county. I mean, I had a client who had to move out of his office building here in downtown Raleigh to make way for the new parking deck. The taking was by Wake County, so he did not recover any moving expenses when he had to move out of his office building. So, I mean, there's so many things that need to be done, and I think North Carolina is probably one of the worst states in the whole country to have a condemnation action.
Professor.
Well, you've mentioned that it's difficult to amend a state constitution, and so I'd like to put on the table for consideration the possibility of making it easier to change the state constitution to adopt some of the property rights protections that some reformers have sought. Currently, there are two ways to change the North Carolina state constitution. 3/5 of the legislatures in both houses can approve an amendment, which is then sent to the people for approval. Or, secondly, 2/3 of the legislatures can agree to hold a constitutional revision convention, which must then be approved by the people before it's called. But 1/3 of the states have an additional way in which you can change your state constitution, and that is through the constitutional initiative process, of where people would get enough signatures together and would say, we want to hold a vote on a constitutional change that might be blocked by legislators or by interest groups for various reasons. In fact, some of the post-Kelo changes that we've seen, the Colorado annexation referendum provision that I mentioned, were passed through the initiative process. That is, the legislators were not keen on providing these protections, and so the people secured those protections through their own initiative. So in short, one of the ways to secure greater protection for property might first require making it even easier or creating an alternative mechanism for changing the Constitution to secure those changes.
Your Honor, on this question, you do get the last word.
One of the changes I would personally like to see is to harmonize Chapter 40A and Chapter 136. As Emmett mentioned earlier, under Chapter 136, when the DOT takes your property, it is possible that you can receive no compensation whatsoever if the DOT tries to assert that their new road is actually going to improve the value of your property so that you are better off without the property that was taken than you were before. So I'd like to see the exemptions for cities and towns to come under 136 to be removed, and I would like to see the 40A standard of damages, whether the property owner can either get the fair market value before and after the taking, or the jury can determine the value of the property actually taken. So my recommendation for change would be to adopt the 40A standard to let a jury award the property owner damages under either or, and to eliminate the exemptions that allow cities to come over under 136 to take property and not pay the property owner a penny for it.
Very good. It's time for us to hear from you and questions that you have been submitting throughout the night. Jack Alphin of Raleigh writes, how is the City of Raleigh's property ordinance constitutional when it may take the right of landlords to rent their property?
Well, having served on the city council, I can't say I'm exactly familiar with the statute, but I can tell you that I think the analysis would be one of whether there's been a taking. And the law generally gives large latitude to municipalities to regulate housing, comfort, safety, and the like. And so at some point, though, when there's been a taking, say there's been a forced annexation, for example, and they're taking an entire community, and there's common areas in there, there's fencing, roads, and they take it all in, I think a valid argument can be made that you've had a constitutional taking of one of your property rights. So if you can characterize the prohibition of the landlord, and I don't know whether you can or whether you can't, as a taking of a property right, then it should be at least theoretically subject to compensation as a cause of action.
Anybody else want to weigh in on that one?
I think it's really a balancing act, and if it destroys all economic viability of the property, then it's a taking, a regulatory taking. Anything short of that, the courts are going to apply this balancing test and look at what the government's trying to accomplish and kind of the nobility of the goal in a way versus how much the property, the investment-backed expectations of the owner is some of the language that they use. There was a case probably many of you are familiar with several years ago down in South Carolina in which a property owner owned a piece of coastal property, and he was limited and he was not allowed to put any houses on this property. The only thing he could probably put on it, I think, was a walkway. It was the Lucas case. And in that case, they said, well, that took all the economic viability out of the site. A more recent case up in Rhode Island, the court involved a piece of coastal property again. It was 18 acres. And with all the regulations, they weren't allowed to fill the property, and at most they were probably going to be able to put one house on this 18 acres, which was worth about $200,000. And the question became, does that destroy all economic viability? Well, no, but how much? And is it enough to constitute a taking? And the court said they sent the case back to the lower courts to try to apply that balancing test. So you don't know, but it's a very difficult standard to meet.
This from J.D. Solomon of Clayton. Please discuss the constitutionality of riparian rights versus water allocation related to surface water use. With our growing population and economy, how big will this issue be in the future?
Well, you know, they're now in the Neuse River Basin, which is where we are, there are riparian buffers on either side of perennial streams. Old word was blue line streams. Some of the municipalities, the state standards are 50 feet right now. Some of the municipalities apply, like Cary, I think, has 100-foot buffers, and I think maybe Apex does too in some places. There was an unreported Court of Appeals decision, the Hashimi case, in which Mr. Hashimi said, wait just a minute, we already got a state law, how can you, Cary, impose a higher standard? And he won, or kind of. It was an unpublished opinion. At any rate, I do think that water rights and, you know, not enough of it, not enough clean water is going to continue to be an issue in our society. And I see the buffers around streams that lead into our drinking water becoming bigger. And you know, if you have a piece of property that was developable and now it isn't because it has these buffers on it, that may very well be a regulatory taking.
To add to that, watershed ordinances. Represented a client before I went on the court that owned property that was 15 miles from the Cape Fear River. However, he was in the Cape Fear River watershed. And the ordinance required him to leave 30% of his property undeveloped. So when he went to develop the property, the amount of buildings that he could put on that property was reduced by 30%. So it was a density loss. And the other 30% was basically just a set aside or a wetland, not even wetland. There was no water or anything 15 miles away, but yet he was still within the watershed and he had to leave 30% of his property undeveloped.
What rights, if any, does the community have when property is taken by eminent domain and the use of the property is objectionable to the community? This is from Paul Barth, and he says, in other words, the community is damaged. So if that happens, what rights does the community have?
Well, it'll be a standing issue, and I think maybe it was Emmett that touched on it. We don't know of a case in North Carolina where the actual governmental purpose for the taking has been successfully challenged. And I think that may be driven by the economics of the circumstance, but also very, very difficult because broad latitude has been given to the municipalities and the sort of blurring, if you will, of the distinction between a government purpose or government use. So I think that probably the first offense to a person in public at large saying, I don't think you should condemn someone else's private property even though it's not my property, I think there'd be a standing issue for that person to, as a threshold to get into court anyway.
Many counties are using zoning to preserve the, quote, rural character of the county. Chatham County is considering ordinances that force all commercial and retail businesses into 10 intersections and declaring 23,000 acres along major roadways off limits to commercial and retail businesses. Here's the question: is this a legal use of governmental police powers? What do you think, Professor?
Well, I think the courts are going to, employ a weighing kind of thing, an ad hoc factual determination. I think it'll depend. I'd say it's it's going to be a tough road.
You want to pass on this?
No, but I'll tell you what, I bet you when that road was built, when those roads were built in Chatham County, that they told the folks that if you let us put this road through, the value of your property will go up. And then after they build the road, then the locals come back in and say, well, we're going to prohibit you from building within 200 feet of your road frontage. It's happening, folks. It really is happening.
Here's a reference back to Kilo. Kilo, I'm pronouncing that right? Thank you. How often, if at all, is North Carolina allowed a taking for a private purpose? Is legislative action an attempt to fix a problem that does not exist?
Well, one would have to take a look at the case that is probably most in folks' mind, and that's the Federal Express case, where the Piedmont Triad Airport Authority exercised eminent domain for the purpose of the Federal Express facility there that did come up before the North Carolina courts, and the North Carolina courts ruled that that was not an improper taking of property. The case has been discussed here, but it bears emphasizing that they said, well, we have to determine, was this a public use, as we've interpreted our law of a land clause as requiring. And they said, well, public use is really distinct from public purpose, but we can use the same analysis that we've used to determine what's a public purpose to determine what's a public use. Now, if you think about that, though, public use is a pretty specific. It's used by the public. The more you broaden things and discuss public purpose, the more it becomes possible to say, well, that would be very nice for the public to benefit from the tax revenues, from the provision, from this company being here. So one could get into an actual count of how many times has eminent domain been invoked for problematic purposes. But another way to analyze this is to look at the way a doctrine has been brought in, interpreted, and some folks would see concerns about what that doctrine opens up for the future.
Here's a question about annexation, and this one has a specific constitutional reference. It's from David Williams of Raleigh. When a property is involuntarily annexed, the property owner suddenly becomes subject to the municipal property taxes attached to that municipality. Doesn't this violate Article 1, Section 8 of the North Carolina Constitution?
Such arguments have been advanced in North Carolina courts in the past, as we've heard earlier, and they have been unfailingly unsuccessful with the North Carolina courts. As we've heard, there have been a number of efforts to raise constitutional challenges to the very idea of annexation laws in North Carolina. The North Carolina courts have said those will not succeed in our court. So the protections that one will get, as was mentioned earlier, but bears reemphasizing, will come through statutory changes to the North Carolina annexation laws. There's little reason to believe that constitutional-based challenges of the kind that you've mentioned, no matter how well-grounded they might be in doctrinal or theoretical justification, will not be a route to success.
We'll close with this question. It's, I think it's fair to say, maybe more philosophical than specific. Will the, or can the, erosion of property taxes eventually lead to the erosion of what this person asked, all other rights?
Well, if we take a founding perspective, and that is if we look back at some of the writings of those in the state of North Carolina in the 1770s, in the original 13 states in the 1770s to 1780s, there was little doubt among those who founded the state, founded the country, that property rights were fundamental rights, and on the strength of the protection of those property rights would oftentimes depend the health and strength of many other rights.
The Article 1 of our state constitution has 37 enumerated rights that are reserved to the individual citizens of our state. The federal constitution, the original Bill of Rights, only had 10. North Carolina was next to the last state of the 13 original colonies to ratify the U.S. Constitution. And part of that was due to the absence of a Bill of Rights. So the delegates here in North Carolina insisted upon a Bill of Rights to be added to the Constitution before North Carolina would adopt it. The biggest stick in the bundle we call property rights is the right of exclusive possession, or the right to exclude others. It is the basis of our civil and criminal trespass laws that an owner of private property has the right to exclude others and to exclusively use it. The question asks more about taxation. And I don't really understand, but I'm going to try to answer the taxation. We just had a reevaluation down in Cumberland County. The average property tax, the values went up anywhere from 30 to 50% over 6 years ago. I personally had a piece of farmland that went up from $110,000 to $550,000. I'm appealing that, but it's going to get to a point where citizens cannot afford to keep their property. The folks who are on fixed incomes, the folks who do not have discretionary income, when you see values increase 30, 40, 50%, and if your taxes go up as much, a lot of folks are going to lose their property because of the level of taxes. Cities and counties are supposed to be revenue neutral. They're supposed to lower the tax rate to equate to the same value as before the reevaluation. But we're seeing now that a lot of cities and counties are not doing that, and that a reevaluation is actually significantly increasing the taxes that an individual property owner pays.
Does one erosion affect the other?
I think it does. You know, the government can take from us in two ways. They can tax us or they can take our property. And the government's doing a pretty good job of taking both. I think there's no more singular issue that galvanizes people than property rights issue. And many people came tonight and will be listening to this program, have been affected by it in different ways. You know, we talk about life, liberty, and the pursuit of happiness. That actually comes from an English phrase, life, liberty, and property. And we talk about a man's home being his castle. The last bastion that separates us from many societies is the right to own land. I believe that many of the people that came to this country and founded it, both for religious reasons, but also for the right to own property. And if we lose that right, if we lose what it means, if we don't stand up for it, we will lose it. And we're losing it incrementally. And I love the great Tar Heel state, but we've got to do something about the property laws here.
Last word.
Well, it's a slippery slope. I hope that's not the case, but I think it could be. So, something for all of us to be concerned about. We need to be vigilant about our rights.
Our deep and sincere thanks to the collective wisdom of this panel tonight. Thank you. And again, as the panel mentioned, our thanks to all of you who took your time tonight to come for this interest because of the importance of this issue. And again, we thank the sponsors of this program tonight. And remember, this can be viewed later, and for those folks that you may know who wanted to attend tonight and couldn't, please let them know that they can find this on carolinajournal.tv. Thank you and have a very good night.